Welcome to the Compliance Counsel on Command webinar series. Today's topic is mortgage periodic statements. I'm Jeff Anderson, an attorney at Dickinson Law that works with community banks with a focus on regulatory compliance. So the mortgage periodic statement rule is part of the mortgage servicing rules that came out in January of 2014. The mortgage periodic statement rule is part of the truth in lending servicing requirements. So your servicing rules are really broken into RESPA servicing rules, which are in Regulation X, and truth in lending servicing rules, which are in Regulation Z. This one's over in Regulation Z in 1026.41. Prior to January of 2014, there was no requirement to provide periodic statements for a closed-end mortgage loan. Many banks did. Many banks included one as part of a combined statement with deposits or with credit cards or other loans. But there was no requirement in the regulation to provide a periodic statement. There was no content and timing requirements. Now there is, subject to certain exemptions that we'll talk about. The coverage of this rule is very broad. Closed-end loans secured by a dwelling. So the HELOCs, your open-end HELOCs, there was already an existing regulation requiring HELOC statements. That hasn't changed. That regulation is still out there and has not been amended with these new rules. The new rule requires a brand new statement for closed-end transactions secured by a dwelling. The only product exemptions from this rule are reverse mortgages and timeshares. Two other exemptions, one for small servicers, an entity-level exemption. If your entity is a small servicer, you're exempt from this rule. The other is what's deemed the coupon book exemption. So in certain instances, you can provide a coupon book with certain information in lieu of providing a periodic statement. The coupon book exemption to me isn't really an exemption. It's more of just another way to comply with the rule, because the fact of the matter is most of you weren't providing a coupon book prior to this rule that had all of the content that they require under this rule. So there's some changes either way. So it's really just an alternative way to comply with this rule in providing coupon books. So let's talk about the small servicer exemption. A small servicer is defined as a servicer that services 5,000 or fewer mortgage loans for all of which the servicer or an affiliate is the creditor or an assignee. Let's break that definition down a little bit. Talk about mortgage loans, same as the coverage of this rule. Closed-end, consumer credit transactions secured by a dwelling. That's what you're counting for mortgage loans. So what's going to count towards that 5,000 threshold? Well, first, you're going to count all the loans for which you're the creditor and that you service in-house. So if you're servicing loans in-house, all of those are going to count towards the 5,000. If your affiliate is servicing the loans for you or for itself, so if the bank or the affiliate is the accreditor and either one are servicing the loans, those are going to account too. Really, an affiliate is just treated the same as the bank. And when we say affiliate, we're talking about that General Bank Holding Company Act definition of an affiliate. An affiliate has to be an entity over which the bank has some form of control. If it's wholly owned, it's clearly an affiliate. If it's 51% owned, it's more likely than not an affiliate. You know, if it's 25% or less, probably not. In between 25 and 51 can be a bit of a factual issue for which you need to dive into that definition in a bit more detail. But you're going to count your affiliate loans the same as you. So what about loans that you subservice? So that's where you get to the difference between selling off servicing and subservicing. So if you sell the servicing of a loan off, if you sell the whole loan off, that's not going to count along with the servicing. If you just retain the loan but sell the servicing rights, that's not going to count either. You're not the servicer on that loan anymore. You've contractually passed off that obligation to service the loan. If, however, you don't sell the servicing off and instead you retain a subservicer to service the loan on your behalf, those are going to count. So towards that $5,000, you count any loans that you or an affiliate service in-house, and any loans that you're the master servicer on, and you've just engaged with a subservicer to service on your behalf. That's what you're going to count towards the $5,000. The other thing that is going to, so this language that states for all of which the servicer is the creditor or an assignee, what that really means is if you're servicing any loans for another entity, so if you're servicing loans for another bank that's not affiliated with your bank, you're automatically out of this exemption. Doesn't matter how many you service. If you're servicing them for another bank, there's a limited kind of exception to that exception for pro bono servicing. But generally, if you're servicing loans for anyone else, you're not a small servicer anymore. Okay. So how is that 5,000 threshold evaluated? It's evaluated based on loans as of January 1st for the remainder of the calendar year. So if that threshold is crossed at any time during the year, you have the later of 6 months or until the following January to comply. So if you cross that threshold in May of this year, you're going to have until January to comply. If you cross the threshold in November of this year, you're going to have 6 months from November to comply, because January wouldn't give you much of a ramp-up time to comply with the rule. So if you meet this small servicer exemption, you're completely exempt from the periodic statement rule. You don't need to provide periodic statements. The question that I get from some small servicers is, well, we're already providing periodic statements. By doing that, even though we're a small servicer, do we have to comply with the content and timing requirements of this rule? No, you don't. It may be worthwhile to listen to the rest of this presentation, because some of that content and timing may become kind of an industry standard, an industry norm, but you're exempt from the rule. So you can optionally provide periodic statements if you want, if you're a small servicer. But if you do, you don't need to provide them in compliant with this rule at all. This small servicer exemption was one of the bigger wins for community banks in the rulemaking process. Because when the CFPB initially proposed this rule, they proposed a 1,000 mortgage loan threshold. And they justified that on two faulty premises, multiple, but two main ones that I'll point out. One being that smaller institutions, will mostly be under that threshold and won't exceed it over time, because borrowers tend to refinance outside of that institution every 5 years or so. And so, even as you gain more mortgage loans over time, borrowers are going to refinance out of it. And so the CFPB reasoned that 1,000 will be high enough, because over time, even at smaller community banks where, if you're making 30-year mortgage loans, those are going to stack on top of each other and add up to 1,000 eventually. They say, well, people are going to refinance out of those. Well, that's a bad assumption for two reasons. One, it ignores the reality of community banking. So I think community banks, on average, their borrowers are going to be far more likely to refinance in-house with that community bank, because it's relationship banking. You have a relationship with that borrower. So they're going to be more likely to refinance in-house rather than going outside like many larger bank borrowers would. Also, that assumption assumes that people are refinancing on an average of every 5 years. Of course, that's been true for the last 5 or 10 years, because we've had declining and very low interest rates. But once you get to stagnant interest rate environment or a rising interest rate environment, that's going to cease being true, the volume of refis is going to decrease dramatically once interest rates start rising. And so at that point, the CFPB would have based this exemption on a very false assumption. So they took those comments into consideration and they raised that considerably, up to 5,000. So they went from 1,000 to 5,000. It was a big win for community banks. Now, a lot of banks confuse this small servicer exemption with the small creditor exemption. So your small servicer exemption, that applies to this periodic statement rule, and it applies to certain other RESPA servicing requirements, such as the delinquent borrower servicing rule. Your small creditor exemption, on the other hand, provides exemptions from certain requirements under the ability to repay qualified mortgage rule. So they're two completely separate exemptions. In my experience, more banks fall under the small servicer exemption than fall under the small creditor exemption. The reason being, you can make a high volume of mortgage loans in a year and still fall under the small servicer exemption if you're selling the servicing off. Right? If you're selling to Fannie and Freddie and selling the servicing off, you can still fall under the small servicer exemption, but you're going to be over that small creditor threshold if you're just originating 500 or more. So the timing requirement for the periodic statements. They have to be delivered or placed in the mail within a reasonably prompt time after the due date or at the end of any courtesy period after the billing cycle. So reasonably prompt means generally within 4 days of the close of the courtesy period. So what this means is if you have a due date on the 1st of the month and you have no courtesy period, you're counting 4 days from the 1st of the month. So you're looking at the 5th. So you'd have to deliver or place in the mail within a reasonably prompt time of the due date for the previous billing cycle. So if you had, for your statement for May would have to be sent out by June 5th in that instance. Now, if you have a 15-day courtesy period, now you're taking the 1st of the month, you're adding 15 days, you're up to the 16th of the month, and then you're adding 4 days of cushion for the reasonably prompt requirement. So you're up to the 20th of the month in that instance. Okay? So where this can cause issues for banks is if you have borrowers that have due dates throughout the month. So if all of your closed-end mortgage loan borrowers are due on the 1st of the month, then you can have just one push of statements every month, and everybody will get them within this time period. If, on the other hand, you have borrowers who have due dates throughout the month, now you might have to look at, is there a way we can send them out in batches to do it more efficiently so that we're not just sending them out to individual borrowers based on whenever their due date is. So, for example, if you had a 15-day courtesy period, you divide a month into 2 batches essentially, and you might be able to send out statements in 2 batches even if you have borrowers who have due dates throughout the month, because that 15-day courtesy period will give you a little bit more cushion. So you really have to look at the most efficient way to get this out within the timing. The other timing requirement that can come up is if you send out combined statements. So a lot of banks sent out prior to this rule a brief mortgage statement that was combined with the deposit statement. You can continue doing that under this rule. The challenge that arises is the timing that's required for deposit statements isn't always going to sync up with the timing requirement for the mortgage periodic statements under this rule. So you're going to have to take a close look at that practice if you want to do it and figure out if there's a way to sync those timing requirements up. It might require a change to the billing cycles on your loans to get those timing requirements synced up so you can still send them out in a combined format. You can send these periodic statements out electronically, just like you can really pretty much any disclosure or statement that goes to the consumer you can send electronically. The difference is most disclosures and statements, you need to jump through the e-sign hoops to be able to send it electronically. So they need to agree, and the most cumbersome e-sign requirement is they need to agree in a way that proves they can access that document electronically. So the borrower can't agree in writing on paper form. They need to agree electronically in a way that proves that they can access the document. That's not the case with these electronic statements. They've loosened that up a little bit. So now, for mortgage periodic statements, you can start sending them to borrowers electronically if that borrower has agreed to get any other statement from you electronically. So if they get their deposit statements, for example, from you electronically, you can start sending them their mortgage statements electronically without any other agreement. They're deemed to have given affirmative consent. The problem that I've seen come up with this is it sounds great in practice. And for some banks it can be helpful, but the problem is it can often be difficult for your deposit periodic statement system to communicate with your mortgage statement system in a meaningful manner to ensure that your borrowers who have opted in to get electronic deposit statements get these. So, I mean, if I opt out of getting electronic deposit statements, how does that system notify the loan statement system in a way that says, well, Jeff's opted out of these, he should be opted out of the mortgage statement as well? There can be some technology challenges there. But in the end, I think this is a real positive development, this electronic delivery section in the periodic statement rule. And hopefully it's a model for future rulemaking by the CFPB where they can ease up some of the e-sign requirements, but essentially to reflect current realities. I mean, e-sign came out in a time where, you know, it could be difficult to open up documents online. I mean, depending on what browser you were using or what systems you had. It's not really the case anymore. So it's a very different environment now. So hopefully we continue to see this momentum for easier electronic delivery. You can even, so borrowers can't opt out of receiving of receiving periodic statements. You have to provide them. They can't opt out of it. What you can do is if you're sending them electronically, so say you're sending me emails with a link that says, Jeff, your periodic statement is available now. Click here, log into online banking, and you'll access it. I can opt out from receiving those emails. You're still going to have to post that statement out there on online banking, but I can opt out from receiving those emails. You can have a little checkbox through online banking that allows me to opt out. So the periodic statement requirement has certain content that must be followed. So I put together a document that outlines how the content should lay out, and I have the sample form that the CFPB put out. So let me back out of this and open this document up so you can look at it. So I'm glad to send this document to you. If you want to shoot me an email or give me a call and I can email it to you. I've really just excerpted out and summarized the content requirement for the periodic statement. So you have a box with the amount due, explanation of amount due, past payment breakdown, transaction activity, partial payment information, contact information, account information, if they're delinquent, delinquency information. I won't go through these and read this in great detail. Again, let me know if you want a copy of this, but I'll just highlight, you'll see here, a lot of these have very strict formatting requirements. They have to be grouped together in close proximity at the top of the first page of the statement. So this is a very regimented formatting that you're required to follow. So these things have to be grouped in a certain way. They have to be ordered in a certain way. So this is what the model statement looks like. So you'll see things are grouped together. You know, your summary is up here. Your explanation of amount due is grouped here. transaction activities grouped together here. If you go down, when a borrower is in delinquency, it populates this delinquency notice here that has to have certain information. Okay? So it's a very model form driven form. Things have to be grouped in a certain way. And like all model forms, really, I encourage you to, the extent possible, ensure that yours are as close as possible to the model so you get that safe harbor protection, right? You don't want to be worrying. You don't want to have compliance risk out there on the basis of something being wrong on a form, particularly a form that's going to be provided to all of your mortgage loan borrowers. So, you use the model form, use that document I have out there, and compare your forms to make sure that they're compliant with the formatting in the rule. So the coupon book exemption. This exemption only applies to fixed rate loans, first of all. So the mortgage statement rule applies to closed-end loans, fixed rate closed-end loans, and adjustable rate closed-end loans. Your coupon book exemption is only going to apply for fixed rate loans because it's difficult to, in many instances, to provide a coupon book when you have the possibility of the rates adjusting. So if you provide a coupon book that has certain information, essentially it has to have all the information that's required on the periodic statement